I was educated in private Catholic schools here in Cincinnati, Ohio. I went to Miami University and obtained my undergraduate degree, and I obtained my law degree from the University of Cincinnati College of Law. I set out overall to make a difference. I realized that we have two systems of justice, unfortunately, in Cincinnati, Ohio, and I believed that I could make a difference.
Why didn't they want you on the bench?
Well, there are a couple of reasons. As the first African American juvenile court judge, I represented a turn from what the county had been accustomed to. Also, as the first Democratic juvenile court judge in the history of Hamilton County as well, I represented a political deviation from what they were accustomed to. And as you are aware, there are different political ideologies as well as racial differences, I believe, that cause them to be threatened by what I particularly would bring to the bench. And I believe that they were afraid that business as usual would be interrupted by someone such as myself, again, being African American, being female, and also being of the Democratic persuasion, would think differently. And I'm sure, based on my cultural background and even political background, that I do. Also, what people don't realize is that unlike other judgeships within Hamilton County, the juvenile court judgeship is extremely powerful. We're not only judges in terms of making rulings, but we actually control at a minimum of $30 million. That's just a minimum. That includes hundreds of employees. It used to include a facility, Hillcrest, that we owned, but just prior to my taking the bench, Hamilton County privatized that facility. But it was a break from what this county was accustomed to. They've never had a person of African American descent in that type of position, able to impact hundreds of jobs, able to impact the prosecutor's office, and quite honestly, able to impact the type of funding that would continue to flow through Hamilton County based on the type of rulings.
Pastor, were you ever pressured to give certain rulings on certain cases?
I hate to say that there was an element of pressure. I did not succumb to the pressure, and I do believe that is one of the reasons that they didn't want me to remain as a juvenile court judge, because it impacted the budget, if you will, when I made decisions that were contrary to what they wanted me to do. Unfortunately, I do recall a few cases where I was pressured to put children in our Hillcrest facility that is now privatized. And I recall one specific incident where the probation team, we have an extensive probation team at the juvenile court, had recommended on a disposition of a child that I place them in the facility. And I recall thinking that I've had several cases just like this particular case, and that was not the recommendation for those children. And so I asked on the record, why are you recommending that this child be incarcerated or detained, but in cases just like this, you didn't make that same recommendation? And I was later told off the record that there was a need to fill the beds at the facility, and that they were low on bodies, which of course impacted funding. And of course, I didn't place the child in the facility because I didn't believe he warranted, that the particular offense warranted him being placed. But yes, I did feel pressure at times. You might recall that after I was removed from the bench, the prosecutor accused me of murder He made a comment that I was responsible for two people's deaths because I did not lock them up when the prosecutors told me to lock them up until they were age 21. What he didn't say was that the offenses were very minor and did not warrant a child being locked up until age 21. But just his response made it clear that there was this sense that whatever the prosecutors told you to do, that as a judge, you were supposed to follow them. And of course, I had been warned by persons within the court that they were used to getting their way, and that if I did not conform to the pressure that they exerted upon me, that it would be problematic. And of course, as we all know now, it turned out to be problematic.
Pastor Hunter, can you tell us why you were removed from the bench?
Well, technically, I was suspended from the bench because I was accused of crimes in office that originated with the Hamilton County Prosecutor's Office, Joe Dieters. Now, the reason I was really removed from the bench is because I was never wanted there in the first place. Persons may recall that in the year 2010, I first ran for juvenile court judge. After the votes were counted, they said that I lost. I knew that I had won that election, and so I challenged the Board of Election with a lawsuit. The prosecutor, Joe Dieters, represented the Hamilton County Board of Elections against me. Additionally, my opponent also entered into the lawsuit and also opposed me. It took 18 months and millions of dollars later for the federal court to make the determination that the votes that had been withheld should be counted. And after those votes were counted, of course, I won. Well, the prosecutor obviously had a personal vendetta and was extremely upset that I had won the election. They did everything that they could. They fought it all the way to the Ohio Supreme Court. And incidentally, the Ohio Supreme Court initially had ruled that they should not count the votes. However, the federal court determined that they should. And it took 2 years, and I believe that that was a certain amount of embarrassment and a whole lot of money that was spent to keep me out of my position. So when I finally got my position and those votes were counted close to 2 years later, the same persons who had opposed me vehemently during the election process continued to oppose me once I was in office. As soon as I got my position, although it was almost 2 years later, I immediately began carrying out the promises that I made when I ran for juvenile court judge. I began to reform the juvenile court system. I began to uncover a lot of things that, quite honestly, were wrong within the juvenile court. I began to find discrepancies in the statistical data, for instance, that was being presented monthly to the Ohio Supreme Court. And I began to oppose signing off on documentation that was inaccurate. And so I began to expose things like that. There was an issue with shackling children. And I made a determination in April of 2013 that I believed that it was an inhumane practice to routinely shackle young people around their bellies and around their ankles and also at their wrists every time they came into my courtroom for a routine procedure. And so I asked the other judge to agree with me to ban shackling. He refused, and so I banned shackling within my courtroom. Of course, the sheriffs that were in the courtroom somewhat opposed my action, but I was following best evidence-based practices, which actually right now there's a trend across the United States of America to ban shackling. In fact, the Ohio Supreme Court now is reviewing this very issue, and I have no doubt that they're going to end up on the same side that I ended up on 2 years ago. So I was somewhat ahead of the curve, and that I began to make changes in the system. I began to attempt to do what the juvenile court system was designed to do, and that was to rehabilitate the children. That means that I went to great lengths to craft unique dispositions for children based on the children. I didn't look at the children as numbers. I looked at the children as human beings that were in need of rehabilitation, and I did everything that I could to rehabilitate them. Now, of course, when you focus on rehabilitation as opposed to incarceration, that takes money away from the system. it costs less to educate a child than to incarcerate a child. But when the great deal of your resources comes from incarceration and you somewhat differ in your ideology, then that makes you a threat to the system. And so that's another reason that I was removed from the bench.
Tell us what happened with the credit card.
I was charged with theft in office and misuse of a credit card because I was sued. I was actually sued over 20 times just in a few short months that I had been on the bench. I was sued by the prosecutor's office, I was sued by the Cincinnati Enquirer, I was sued by WCPO television station because I refused to allow the media to print the names of the children or show their faces, which was actually standard practice, but for some reason when I prohibited the media from exposing the children, which would have harmed their efforts at rehabilitation, they all sued me. Well, the prosecutor decided to represent me in the lawsuits that were filed against me. And so, in effect, the prosecutor was both suing me and representing me at the same time, which is actually, it's not only highly unusual, it's actually very unethical. And I repeatedly asked for independent legal counsel that did not have the same type of conflicts, having been sued repeatedly by the prosecutor even prior to taking office, that existed in my particular set of circumstances, and he refused to remove himself from my cases. Ultimately, he threw all of the cases, and in every case that he represented me, I lost as a judge. Well, later on, I guess after about 8 or 9 months of being on the bench, the public defender's office began suing me as well, and they claimed that I was taking too long in some of my cases. The prosecutor was representing me in those cases, and again, I asked for him to remove himself because he was not providing effective assistance of counsel. He refused. I filed an ethics complaint against the prosecutor. In fact, it was about 2 weeks after I filed the ethics complaint that I was accused of crimes in office. I forgot to mention that earlier. I ultimately believe that I was charged with crime as a vindictive response to my filing ethical complaints against the prosecutor's office for the very incompetent way that they were handling the lawsuits against me. When the defender's office sued me, the prosecutor failed to answer any of those lawsuits. And I don't know if you know what happens when a lawsuit is filed. It must be answered in a certain amount of time or else you lose those suits. Well, I was sued as the judge of Hamilton County Juvenile Court. In my official capacity, the prosecutor failed to answer the lawsuits. I complained. He then suddenly terminated his representation, and he appointed 2 private lawyers that I'd never heard of before that were, I guess, friends of his. He appointed them to represent me. One had a background in immigration law, the other had a background in criminal law. Neither of them had any experience whatsoever in juvenile law. And for a prosecutor to recommend that 2 inexperienced individuals with no experience whatsoever in juvenile court represent a juvenile court judge is a little bit ludicrous. Well, nevertheless, the 2 private lawyers that were hired by the prosecutors also failed to file answers in those lawsuits. And all of those lawsuits resulted in default judgments against me as the Hamilton County Juvenile Court or judge, which is ultimately the juvenile court. And so the entire court was negatively impacted because of their failure to file answers in those cases. When I realized the egregiousness of the situation that they had failed to answer, I requested them repeatedly to file an appeal after those default judgments were granted against me. When they refused to file appeals and properly defend me as a juvenile court judge, I then filed notices of appeal myself with the Ohio Supreme Court. I responded as judge in my official judicial capacity. In fact, every document that I signed to that effect was signed in my official judicial capacity, and they in turn, I guess out of anger that I went ahead and defended the lawsuits that they failed to defend, then accused me of crimes in office because the credit card was allegedly used to take care of the fees associated with those lawsuits.
Pastor Hunter, could you please explain to us the school to prison pipeline system?
Absolutely. The school to prison pipeline occurs when we put more children in detention and incarceration than we do in school. In effect, they go straight from the school system directly into the court system. And believe it or not, that happens on a regular basis because now we actually have officers that are in these school systems. And things that years ago just amounted to childish behavior, such as a regular fight on the playground, now becomes an assault charge. Now if children in kindergarten are unruly, they may end up in the court system. And what people don't realize is once a child is introduced to the court system, particularly the juvenile court system, and become entangled, it becomes very difficult to separate that child from the system. In fact, the statistics show that the more early a child comes in contact with the system and the longer a child is detained at the point of contact with the system, the more indicative it is and probable it is that that child is going to have repetitive contacts with the juvenile court system. And eventually what happens is the child gets so entangled with the juvenile court system that by the time they reach the ages of 16 or 17 and they're close to adult age, they start committing offenses that land them in the adult system. And so in effect, you have children that are now spending their youth and their juvenile years entangled in the court system. The real disparities begin at the onset of the process in the arresting decisions as well as the prosecuting decisions. How a juvenile is prosecuted will ultimately determine if a child is adjudicated delinquent, how they will be ultimately sentenced. And I must say that Hamilton County has the highest bind-over rate of any county in the state of Ohio. A bind-over is trying a juvenile as an adult. We are the third largest county. We are third in comparison to Franklin County, that's Columbus, which is second, and Cuyahoga County, which is number one in terms of size. However, we outnumber trying children as adults almost 3 to 1 than Cuyahoga County. And so I am not sure because the urban core of Cincinnati does not vary that greatly from Cuyahoga County, and so I'm not sure, other than the way that our children are being prosecuted, which constitutes for the large disparity in sentencing here. Once a child, of course, enters into the system, and I will admit that I rarely saw Caucasian children in my courtroom, very rarely. In other words, the most serious crimes which are heard, or most serious offenses which are heard by the juvenile court judges were pretty much contained to African American children, specifically boys. Over 97% of the children that are ultimately detained in Hamilton County are African American boys. The juvenile court judges try the most serious of offenses. We have magistrates that hear the multiple or the greater amount of lesser offenses. But when it comes to serious offenses such as murder or felonious assault with a weapon, those cases are put before the judge. And so most of the cases, at least delinquency cases that I would hear as a juvenile court judge, involved guns, involved weapons. Now we do know that other children utilize weapons as well. But again, it is impacted at the beginning stages of the process as to how a child is ultimately charged with an offense. And so I could probably count on one hand the number of Caucasian children that came before me in the 14 months that I was sitting on the bench. And it was concerning only from the standpoint that I know that there are offenses that are committed by all ethnicities, but it's how those offenses are being treated in Hamilton County that is very concerning.
Pastor Hunter, is the pipeline working?
Yes, absolutely, in Hamilton County.
And is there a significant difference between juvenile African American and Caucasian sentencing and incarceration?
Well, I think in order to answer that question, we must start where the process begins, and that's not at sentencing. That's at the charging level with the prosecution, the arresting stages with the police. There are often decisions that are made in advance of any sentencing that influence ultimately the disparate or disproportionate rate of sentencing between African Americans particularly and Caucasians. How an offense, now in the adult system it's called a crime, in the juvenile court system it's called an offense. How an offense is treated at the onset often determines the disparity. Many times Caucasian children may never enter into the system because they are headed off, either because they're never arrested or because maybe they are referred to in an official docket and they never enter into the system.
Can you explain the situation with your brother?
I was charged with securing a public contract for my brother. My brother worked for the juvenile court system since the year 2007. I did not take my seat as a juvenile court judge until the year 2012 in May. I had absolutely nothing to do with my brother working for the Hamilton County Juvenile Court.
Pastor, can you explain why have you asked for the removal of Judge Dinkelacke from your case?
Absolutely. Judge Patrick Dinkelacke is my peer judge. He is a common pleas judge, just as I am a common pleas judge. We both work for the Ohio Supreme Court. We both make the same exact salary. He just works for the Common Pleas General Division, and I work for the Common Pleas Juvenile Court Division. And there is a body of case law that makes very clear that in a jurisdiction that one judge should not rule over any matters involving another peer judge. And what makes this particular instance so egregious is that Judge Dinkelacke is right now the defendant in a wrongful death lawsuit. And he was immediately assigned a visiting judge outside of Hamilton County. Joe Dieters has been going through a divorce during the last couple of years, and his case was also assigned to a visiting judge, and he's a prosecutor. And so there seems to be a great deal of disparity and actually discrimination in how I have been treated as an African American judge as opposed to a Caucasian judge, as well as a prosecutor, who have both been given visiting judges while subjecting me to judges that are politically connected to all of the people that are involved in these charges and in these false accusations against me. There is no separation here. And the rules of conduct for both lawyers and judges say that we must avoid even the very appearance of impropriety. And when you have a prosecutor who has received campaign contributions from both the prosecutors, in fact, those were his personal defense lawyers, have been for the last decade, as well as his personal divorce lawyers. He then recommends two special prosecutors, neither of which has ever been a prosecutor. They've been defense lawyers their entire careers, and all of a sudden their personal buddy, Joe Dieters, makes them special prosecutors to charge me with crimes. They have given financial contributions to the prior judge, that was Judge Norbert Nadel, as well as this current judge. And so when you look at the way the money is connected, when you looked at the politicism, and again, I'm the first African American and the first Democrat judge, and this is pretty much being orchestrated by the Republican Party, it gives great pause to the partiality of, or the impartiality rather, of the decisions that are being made here.